If you are a green card holder and you have traveled internationally this year, or if you are planning to travel in the coming weeks or months, this video could save your permanent resident status. Something has fundamentally changed at American airports in 2026. Lawful permanent residents who have traveled freely for years are now being pulled aside, sent to secondary inspection, questioned for hours, having their phones searched, and in some cases being pressured to sign away their green cards on the spot. This is not speculation. This is not fear-mongering. This is happening right now at airports across the United States, and immigration attorneys are sounding the alarm. A February 2026 report from Money Control confirmed that across major U.S. airports, green card holders are being pulled aside for longer questioning, sent to secondary inspection, and in some cases warned that their residency status could be at risk. Immigration lawyers and advocacy groups say this reflects tighter enforcement rather than a new law, but the impact on travelers is real and growing every week. In this video, I'm going to explain exactly why green card holders are being targeted, what CBP officers are looking for, what triggers will send you to secondary inspection, what happens when they search your phone, the Form I-407 trap that could end your residency forever, the new biometric tracking system that is now monitoring every entry and exit, the TSA ICE data sharing pipeline that has already led to over 800 arrests, and the exact steps you need to take to protect yourself before your next flight. Stay until the very end, because I am going to give you a complete travel preparation checklist that every green card holder needs. Let me start with why this is happening now. There are 6 major changes in 2026 that have converged to create the most dangerous airport environment for green card holders in modern history. The first change is the deployment of ICE agents to airports. On March 23, 2026, Immigration and Customs Enforcement agents were deployed to at least 14 airports across the country. The Trump administration initially claimed this was to alleviate staffing shortages caused by the DHS government shutdown, as hundreds of TSA workers had resigned and thousands called in sick after not being paid for over 44 days. But President Trump himself then described airports as fertile territory for ICE to arrest immigrants. Tom Homan, the White House border czar, confirmed on March 29 that ICE agents would remain at airports until normal operations resume. As of April 2026, ICE maintains a heavy presence at major airports including JFK, LaGuardia, San Francisco International, LAX, O'Hare, and others. The second change is TSA ICE data sharing. Before the current Trump administration, TSA agents did not share data related to the immigration cases of domestic flight travelers. That changed in March 2025, according to the New York Times. TSA now shares screening data with ICE. According to Reuters, which obtained ICE internal data in April 2026, TSA provided records on approximately 31,000 travelers who were flagged for potential immigration enforcement. This pipeline has led to more than 800 arrests from the start of Trump's presidency through February 2026. On March 23, 2026, a woman named Angelina Lopez Jimenez was arrested at San Francisco International Airport after TSA tipped off ICE agents. She was traveling with her 9-year-old daughter on a domestic flight. The third change is the biometric entry-exit tracking system. Effective December 26, 2025, CBP implemented a final rule requiring facial recognition photographs for all non-citizens, including green card holders, at every U.S. airport upon entry and exit. This means the government now has a precise digital record of every time you leave the country and every time you return. Before this system, CBP relied on airline records and passport stamps, which were imperfect. Now the tracking is automated and comprehensive. If you have been outside the country for 181 days or more, the system flags it automatically, and that flag follows you to the inspection booth. The fourth change is the massive increase in electronic device searches. CBP searched 55,318 phones, laptops, and other electronic devices in fiscal year 2025, a 17.6% increase from 2024 and a 32% increase from 2023. In January 2026, CBP issued a new directive clarifying and expanding the scope of permissible searches at the border, and wearable devices like smartwatches are now included. Under long-standing border search doctrine, CBP officers do not need a warrant or probable cause to conduct a basic search of your electronic devices at a port of entry. This applies to green card holders, just as it applies to everyone else crossing the border. The fifth change is the new DHS Secretary, Markwayne Mullin, who was sworn in on March 24, 2026, after Kristi Noem was fired. While Mullin has signaled a more procedural approach to enforcement, including requiring judicial warrants for home entries, he has also raised the possibility of withdrawing CBP officers from airports in sanctuary cities, and has stated that ICE agents will remain focused on enforcement at airports. Immigration attorney Sekou Clark has warned that under Mullin, the approach may become more organized, detailed, and targeted, which does not mean less enforcement, but rather more efficient enforcement. The sixth change is the broader climate of fear. According to PRISM reports, ICE presence in airports has caused fear and limited the mobility of non-citizens and people of color. Reddit threads about ICE at airports have received hundreds of responses from people expressing anxiety about flying domestically, with many suggesting taking trains instead. A Muslim woman interviewed by PRISM described seeing ICE agents behind TSA staff checking IDs at JFK and feeling anxious about her flight. The chilling effect on travel is real, even for people with valid status. Now let me explain the specific triggers that will get a green card holder pulled aside at the airport. Understanding these triggers is the most important thing you can take away from this video. The number one trigger is extended absence from the United States. According to CBP's own guidance, staying outside the United States for more than 6 months but less than 1 year will subject you to additional questioning when you return. Absences close to or exceeding 1 year often lead to detailed interrogation and can result in a finding that you have abandoned your permanent resident status. CBP officers will ask where you live, whether you are employed in the U.S., who your immediate family members are, and where you file taxes. The underlying question is simple: is the United States still your primary home? The second trigger is travel pattern inconsistencies. If you have taken multiple trips abroad that cumulatively add up to significant time outside the country, even if no single trip exceeds 6 months, CBP may flag this pattern. The biometric entry-exit system now tracks every departure and arrival with precision. Officers can see your complete travel history on their screen and calculate exactly how many days you have spent inside versus outside the United States over any given period. The third trigger is a mismatch between your stated ties and your documentation. CBP officers may ask about your U.S. employment, your home address, your utility bills, your children's school enrollment, and your tax filings. If you cannot produce evidence of ongoing ties to the United States, or if your answers are vague or inconsistent, you will be sent to secondary inspection for further examination. The fourth trigger is criminal history or prior immigration issues. If you have any criminal record, any prior encounter with immigration enforcement, any outstanding warrants, or any flags in the DHS database, you will almost certainly be sent to secondary. Under the current administration, the threshold for what constitutes a concern has been lowered significantly. The fifth trigger is country of origin. This is uncomfortable to state, but important to understand. Reports from travelers and immigration attorneys confirm that green card holders born in certain countries face disproportionately higher rates of secondary inspection. CBP has wide discretion in determining who gets additional screening, and country of birth is one of the factors officers consider. The sixth trigger is your electronic devices and social media. CBP's January 2026 directive allows officers to conduct basic searches of your phone, laptop, tablet, and now wearable devices without a warrant. If officers find content that raises concerns, such as messages suggesting you live abroad, social media posts from foreign locations, photos that contradict your stated travel dates, or any content deemed objectionable, the consequences can range from extended questioning to referral for formal immigration proceedings. Now let me talk about the most dangerous thing that can happen to you at the airport, and that is being pressured to sign Form I-407. This is the form that officially records the abandonment of your lawful permanent resident status. Signing it means you voluntarily give up your green card. It is irreversible. Once you sign, your life in the United States as a permanent resident is over. Immigration attorneys across the country have reported a sharp increase in cases where CBP officers pressure green card holders to sign Form I-407 during secondary inspection. The pressure is particularly intense on elderly green card holders, those who speak limited English, and those who have been outside the country for extended periods. A Reddit thread titled, "Grandparents Pressured to Surrender Green Cards at U.S. Airports" documented multiple cases of elderly permanent residents being told they needed to sign the form, often without understanding what they were signing. Here is what you need to know about Form I-407. No CBP officer can force you to sign it. It is voluntary. No matter what they say, no matter how much pressure they apply, no matter how long they keep you in secondary inspection, you have the right to refuse to sign. If an officer presents you with Form I-407, you should politely but firmly decline to sign. You should state that you wish to speak with an immigration attorney before signing any documents. You should ask for the officer's name and badge number, and you should not answer any further questions without legal counsel if you feel your rights are being violated. If CBP believes you have truly abandoned your residency, they have other legal mechanisms to pursue that determination. They do not need your signature. The reason they want your signature is that a signed I-407 is the cleanest and fastest way to terminate your status, and it is much harder to challenge afterward. Do not make it easy for them. Let me now address what happens during secondary inspection itself. When a CBP officer sends you to secondary, you are escorted to a separate area of the airport, where additional officers will interview you in more detail. Secondary inspection can last anywhere from 30 minutes to several hours. In some reported cases, travelers have been held for 8 hours or more. During secondary inspection, officers may ask you detailed questions about your employment history, your residential history, your family situation, your tax filings, your travel history, and your intentions for future travel. They may ask to see your phone and laptop. They may run additional background checks. They may contact other agencies. The atmosphere can be intimidating, and officers may use high-pressure tactics to get you to make admissions or sign documents. Your rights during secondary inspection as a green card holder include the right to remain silent on questions that could incriminate you, the right to refuse to sign any documents, the right to request an attorney, and the right to not consent to the search of your electronic devices. Although CBP may confiscate your device for further examination if you refuse. You cannot be deported on the spot during secondary inspection. If CBP believes you have abandoned your residency, they must initiate formal proceedings before an immigration judge, unless you voluntarily sign Form I-407. Let me now give you the complete travel preparation checklist that every green card holder needs before flying internationally in 2026. Before you travel, make sure your green card is valid and not expired. If it is expired or expiring within 6 months, file Form I-90 for renewal before you travel. Carry your original green card, not a photocopy. If your green card is expired, but you have a receipt notice from a pending I-90, carry that receipt notice along with your expired card. Prepare a travel folder with physical copies of documents that prove your ongoing ties to the United States. This should include your most recent U.S. tax return, an employment letter from your U.S. employer dated within the last 30 days, a copy of your lease or mortgage statement showing a U.S. address, a utility bill in your name at your U.S. address, health insurance cards, your children's U.S. school enrollment records if applicable, and any bank or financial statements from U.S.-based accounts. The more evidence you have of a life based in the United States, the smoother your re-entry will be. If you plan to be outside the United States for more than 6 months, file Form I-131 for a re-entry permit before you leave. You must be physically present in the United States when you file. The re-entry permit is valid for up to 2 years, and demonstrates your intent to maintain permanent residence despite the extended absence. Filing for a re-entry permit does not guarantee that CBP will admit you upon return, but it significantly strengthens your position. Keep your trips under 6 months whenever possible. The 6-month mark is the bright line that CBP uses to trigger additional scrutiny. Staying abroad for 5 months and 29 days is treated very differently from 6 months and 1 day. Plan your travel accordingly. Review your electronic devices before you fly. Remove or secure any content that could be misinterpreted by a CBP officer during a device search. This includes messages, photos, social media posts, and browsing history that could suggest you live outside the United States, have expressed views that could be deemed objectionable, or contradict your stated travel history. Consider traveling with a clean device, meaning a phone or laptop with minimal personal data, and accessing your primary accounts through the cloud after you have cleared customs. Know what to do if you are sent to secondary inspection. Stay calm, be polite but firm. Answer basic questions about your identity and your trip. Do not volunteer information beyond what is asked. If you are presented with Form I-407, decline to sign and request an attorney. Do not lie, because making a false statement to a federal officer is a crime, but you do not need to answer every question in detail without legal counsel present. Have an emergency contact plan in place. Before you fly, give a trusted friend or family member the phone number of an immigration attorney who can be reached if you are detained. Programs like the ACLU's Know Your Rights cards and the National Immigration Law Center's airport resources are available for free and should be saved on your phone and printed on paper. If you are admitted but receive a warning from CBP about future travel, take it seriously. Document what was said, including the officer's name and badge number. Consult with an immigration attorney as soon as possible after your return to assess your risk and develop a strategy to strengthen your residency evidence for future trips. Let me give you the critical numbers for 2026. ICE agents are deployed to at least 14 airports nationwide since March 23, 2026. TSA shared records on 31,000 travelers with ICE, leading to over 800 arrests through February 2026. CBP searched 55,318 electronic devices in fiscal year 2025, up 17.6% from the prior year. The biometric entry-exit system has been in full effect at all U.S. airports since December 26, 2025. Trips over 180 days trigger automatic CBP flags and additional questioning. A re-entry permit through Form I-131 protects you for up to 2 years of absence. The USCIS contact center is 1-800-375-5283. The United We Dream helpline is 1-844-363-1423. The AILA Lawyer Referral Service is at aila.org. Find an attorney. Let me put this all in perspective. A green card is not just a travel document. It is a declaration that the United States is your home. In 2026, the systems that monitor whether you are actually living up to that declaration have become more sophisticated, more connected, and more aggressive than at any point in history. The biometric system tracks your every departure and arrival. The TSA shares your data with ICE. CBP officers have broader authority to search your devices. ICE agents are physically present at airports for the first time in history, and the political pressure to demonstrate enforcement results means that green card holders who are easy to stop, easy to question, and easy to pressure are the ones most likely to be pulled aside. The green card holders who will navigate this environment safely are the ones who prepare. They keep their trips short, they carry their documentation, they know their rights. They never sign Form I-407 without an attorney. They review their devices before flying, and they treat every international trip as a potential encounter with federal immigration enforcement, because in 2026, that is exactly what it is. If this video helped you, hit the like button, subscribe to the channel, and share this with every green card holder you know who travels. Drop a comment below and tell me about your experience at airports this year. Have you been sent to secondary? Were you questioned about your travel history? I read every single comment, and your experiences help the entire community stay informed. Stay informed. Stay prepared. Stay safe. I will see you in the next one.